Okay, well, let's make a start. Good afternoon, everybody, and good afternoon, Hugh, again, and thank you for
Afternoon,
joining
Ed.
us, Hugh. Just a few words quickly by way of introduction. NRC Medical Experts is a chambers, rather like a barrister's chambers, of experts in neurological rehabilitation, predominantly consultants in rehabilitation medicine, neuro-rehab, and also neuropsychiatrists and neuropsychologists, with some therapists, all in the related discipline. And we've been running for about 7 years, providing expert witness reports for the courts, both claimant and defendant, and the service is growing and becoming more widespread. We offer service across the UK, and of course, many of you who are attending will have used us. I do notice, in fact, we have a very long, unprecedentedly long list of attendees at this webinar, which is very gratifying. I think at last count it was 193. Now, clearly not everybody will have been able to attend, but we have still a very substantial number attending, and I thank you for doing that. In particular, I note, although we originally intended that this was a webinar for experts to ensure that they understand the issues about capacity and assessment of it, we noticed that, yes, while there are quite a lot of experts attending, there are also quite a lot of case managers, but the predominant attendees are in fact solicitors. So Hugh is on home ground with the solicitors, and in particular, we have, I think, 20 attendees from Clyde & Co, which is a defendant firm, and of course we're very glad to have you on board, as well as everyone else. I'm particularly interested to hear from the team at Clyde & Co about your perspective on capacity assessment, because we don't often get into that dialogue with the defendant solicitors. So please do speak up. There is opportunity to have a Q&A both throughout Hugh's presentation, and I will moderate that. And of course, there'll be time at the end. So don't be shy, please ask your questions. And if there's anything that you want to pick out as Hugh's going along, stick your question up and I will be monitoring those. So without further ado, Hugh, who is a partner at Enable Law and is a long-standing friend of NRC Medical Experts, has presented us a number of our internal meetings and CPD events for our experts, has kindly offered to give this this hour-long session on capacity assessment. Hugh, over to you. Thank you.
Thank you, Ed, and hello everyone. Thank you for joining today. Next slide, please. Just a very quick introduction about me. So I am predominantly a claimant lawyer specializing in traumatic brain injury work, something that I've been doing for a reasonable period of time. I also have a court of protection practice as well, which I've had for about 20 years. So I've got those sort of dual perspectives. I also wear a volunteering hat, both with Headway, previously with a carer-focused organisation in Wiltshire, and prior to that at a hospital in Bath. So a fairly sort of wide range of experience. So next slide, please, and we'll get into the real meat of today. So what are we going to do? Well, I thought it would be useful, first of all, to just recap the important aspects of the Mental Capacity Act that we should all know, to share my experience of how I've seen experts deal with this historically. Then we'll look at some recent developments, and I want to particularly focus around health and welfare issues as opposed to finance and property. Many of you will be aware that when it comes to deputyship, the vast majority of deputies appointed by the Court of Protection will have power vested in them to manage finance and property. Very few health and welfare deputies are actually appointed. the traditional wisdom being that the Court of Protection prefer health and welfare issues to come before them on an ad hoc basis. I also thought it would be useful to look at how we as lawyers and experts address this area currently and going forward. And I know we've got quite a varied audience today, some of you coming from non-legal or expert backgrounds, which is great, because I think this will be equally of interest to those, whether they come from a case management background or otherwise. And here's my my spoiler alert, my real sort of message in today. It isn't my litigation practice that has evolved the most over the last 5 years, but rather my court protection practice, spilling over then into the litigation, which has become infinitely more complex in this area. We will have time, I hope, for questions at the end, and you've already heard that Ed is going to monitor the chat as we go along, and it might be that I take the odd question as we go through. So hopefully we'll get some interaction throughout today's session. So I think that it doesn't hurt ever just to go back to the Mental Capacity Act and have a look at some of the basics contained within it, which all sound quite straightforward on first reading. So we start within section 1 and the principles there with the assumption of capacity, that for someone unable to make a decision for themselves, or that might be, all practicable steps have to be taken first to help them make that decision before intervening and seeking to make it for them. We shouldn't assume a lack of capacity merely because of an unwise decision. Although I have to say, with my deputy hat on, that's often the bane of my life in terms of a lot of my clients saying to me, well, you've got to give me that money because what I want to spend it on, it's just an unwise decision rather than an indication of me lacking capacity. Where acts or decisions under the Act are taken on behalf of P, the protected party, it has to be done in their best interests and also has to be the least restrictive option, bearing in mind their rights and freedoms. And then in terms of the test, a person deemed lacking capacity to make a decision if at all the material time or times, so time specific and also decision specific, they are unable to make that decision because of an impairment of or disturbance in the functioning of the mind or brain. So quite a prescribed test, and certainly something that I would expect medico-legal experts to be picking up on in their reports. Next slide, please. So going on, section 3, the inability to make decisions, and here we have that sort of extension, if you will, of the test. So how will a person be deemed unable to make a decision if they can't understand the information relevant to the decision specific, retain that information, use and weigh that information as part of that decision-making process, and then communicate that by any means. Could be oral, could be written, could be using technology. And then when it comes to steps taken, decisions made for somebody lacking capacity, that they should also be or always be in that person's best interests, never prejudiced by age, appearance, behaviour, that all relevant circumstances are considered, cultural background, family background, etc. That somebody also might regain capacity. They may lack capacity today, but they could regain it tomorrow. So should we be delaying that decision until that happens? To encourage, where we can, the participation of P, taking into account wishes, feelings, beliefs, and I've already touched upon the views of others. Next slide, please. So, and this is very much a personal perspective, and so comes with that caveat. But how have I seen experts historically deal with this? And this is both claimant instructed and defendant instructed experts. It often appears at the very end of a report, a sort of a and finally, which I think sometimes gives the impression of it being a bit of an afterthought, not central perhaps to the issues that are being considered. That's not always the case, but I would say more often than not, that's sometimes the impression that is given. And then the next point, and of course this will depend very much on the instruction that expert has received. The consideration of capacity, so whether or not the individual has or does not have capacity, tends to be restricted to matters of finance and property. Sometimes also litigation capacity. Does the individual have that capacity to give instructions in their own litigation? But often goes no further than that. Sometimes I will see when I read reports that there might have been limited consideration of the evidence. I know, for example, sometimes on cases I may have disclosed significant volumes of witness statements to defendants, but then when I see the list of documentation that the defendant expert has considered, the witness statements aren't listed. And I wonder whether that's a conscious decision on the part of those instructing the expert that they don't want them to look at them, or perhaps there's another reason. I see perhaps limited forensic analysis of this issue. How do I pick that up? I might say to a client when they come back from seeing an expert, so how much time did the expert spend with you talking through the issues that go to capacity? Now, of course, the client may not always appreciate that the questions being put to them relate to capacity, but often they will, and they might say to me, well, it was 5 minutes or 10 minutes at the end of that appointment. And I'll come back to that later in the webinar in terms of the approach that I think should be adopted in terms of best practice to considering the evidence, not just the evidence that's available perhaps, but it doesn't prohibit the expert from going beyond that and asking other questions. And that's going to then be quite a time-consuming exercise. And when I sometimes see that experts haven't seen evidence, I wonder whether that's almost a sort of a strategy so as to enable them to say that they've not seen anything such that the presumption of capacity, which we've already seen in the principles of the Act, has not been displaced. Next slide, please. So I mentioned that this area of my practice has evolved more than any other in the last few years. For reasons I'll go on to, it is infinitely more complex now than it was 5 years ago. Very contentious, perhaps because of the money involved. And the next two bullets there, we're increasingly seeing now issues going well beyond finance and property, litigation capacity, testamentary capacity. Also, many health and welfare issues, the ability to use social media, care, accommodation, contact with others, sex, and more. So all of that, I think in terms of my practice, certainly has a knock-on effect in terms of the evidence gathering that's needed to enable an expert to give best opinion for the court, let's not forget. how the experts are instructed, but also where findings are arrived at in terms of deputyship, what that means then in terms of the costs. And a little bit later on, I'm going to share with you an anonymized case study, which I hope will bring some of these principles together. Next slide, please.
Hugh, can I just come in there?
Yes.
There's a very interesting question come up from an expert at Faisal Esat. And I think it's probably building on the point that you've made about the defendant experts sometimes not seeing witness statement evidence, which I have to say I hadn't fully appreciated. Whenever I've done defendant work, I think I have seen that evidence, but it's a very interesting point. Anyway, Faisal asks, can you please clarify the entitlement to see the other party's letter of instruction to the expert? He says, I am regularly asked by the other side to disclose my letter of instruction to my expert. Thank you.
Yeah, well, the answer to that is no. But where am I seeing the information that tells me, for example, that certain key evidence hasn't been seen by the expert? That will be, every expert will list in their report the documentation that they've seen, medical records, case management notes, support worker notes, maybe other documentation besides. If they have seen witness statements, I would expect them to say that they have seen witness statements. And if I know that I disclosed witness statements to an expert 6 months ago, to my opponent 6 months ago, but then their expert instructed 2 months ago is saying that they haven't seen them, why is that? And that's probably something that I would then pick up with my opposite number, and of course it may come up in the joint discussion between the experts as well. If one expert has seen all these witness statements and the other hasn't, then perhaps that's not going to result in the most constructive discussion between the two of them.
So just to summarize from my own point of understanding, does the letter of instruction that you write to an expert, is that privileged? Is that part of that privileged component?
Yeah, so it won't be seen by the other side. I've not had of course, the vast majority of cases don't go to trial. So I've not seen an incident where a judge perhaps has said, I want to see the letter of instruction, but the letter of instruction wouldn't go, for example, in the trial bundle.
Okay, thanks very much. That helps.
Looking at some of these developments, and these are developments more around, and the thrust of today, a lot of it is going to be around health and welfare issues, as opposed to finance and property. So not can this person manage this amount of money, or buy or sell this property, but rather these health and welfare type issues. And here's the case re ACC that many will refer to frequently in this area. And so Judge Hilda in that case refers to Property and Affairs Deputies Authority, and quite categorically that it does not encompass seeking advice on welfare issues, and that those matters should be brought before the court. And it's a wide range. The list then that you see at the next bullet is not an exclusive list. It's the list that arises in the case study that I will share with you. But those issues will have to go before the court first, or an application be made to the court first by a finance and property deputy before they can then go on and explore those issues further. Next slide, please. So I don't intend spending much time on the next few slides, but these are all examples of cases that we have. So when you see reference there to initials AR, that's the client. FATC is the trust corporation that we use. So rather than an individual named deputy, all our deputyships are held within a trust corporation. But the several examples that you will be able to read in your own time after this, there are 4 in total. As I say, I don't really propose to go through them, but they're all applications to the Court of Protection by the deputy to consider various health and welfare issues. And in some of the examples, the court have come back and said, yes, the deputy can commission reports on those areas. But in the very last one, if we skip forward a few slides to example 4, in that one there, the court said that no, it had to be the local authority who had to commission reports and investigate these various issues. And then as we go through, because this relates then to the case study that we'll be looking at, you'll see just how problematic that became quite quickly, and also then protracted over a period of time. So why do I mention these? Only that the Court of Protection itself, as well as taking many months to deal with these applications, which many will be aware of, they do have a varying approach from one judge to another. Next slide, please. So, pulling out some of these issues, I thought it would be useful to look at some examples to put it in context. So, if we look at social media and internet use, as well as then social media and care and contact, because of course a lot of people use social media to open up their social opportunities, there is a risk there highlighted by these 2 cases, that on the one hand, you can generalize too much with these things, and that again I think goes back to expert reports, when it's very easy to make a blanket statement about a particular aspect of capacity. But of course, if you drill down into it, there will be, for example, with social media, there's certain types of social media at one end of a spectrum in terms of its complication and perhaps risk. And there are other social media platforms that look very different. So just to say that an individual does or does not have capacity in respect of social media and internet use is a difficult thing, highlighted then by the second quote that you see, that a determination that an individual lacks capacity to access and use the internet, in that example, would pose a significant restriction upon his or her freedom. And that perhaps demonstrates why the Court of Protection want these issues to come before them, rather than leaving them with the deputy. And it's quite clear now that a finance and property deputy does not have the ability to make decisions in this area beyond perhaps quite straightforward decisions day to day. But for the more significant decisions, you would expect an application to have to go to the Court of Protection first. Next slide, please. So looking at internet and social media and applying the Act and that ability to understand, retain, use, weigh, and communicate, I've set out there just some points, again from personal experience. And the internet is a minefield. It's a minefield for young people anyway, but particularly for our clients with traumatic brain injury. And a lot of clients, they won't understand the basics. That they think if they're talking to Fred, that Fred may not be Fred. Fred could in fact be somebody very different. Fred might say that they're 15 years old, but Fred could be, Bob, who is, 45 years old and in a different country. So, these are complex issues, and I will come back to, because I suspect maybe some of the experts listening this afternoon might be thinking, my goodness me, does that mean that this is up to me to go through all these sorts of things in the course of my hour-long, 2-hour-long time spent with the claimant? Maybe, but also maybe not. But these are complex issues for our clients. Next slide.
Come in there.
Yes, please.
A couple of questions have come up. Laura Rowell, who's an expert, says, if there is any doubt that an individual lacks capacity, is there not a capacity assessment done on this client automatically so that the expert could be aware prior to the assessment?
That's a very good question, and I will pick that up perhaps when we're going through the case study. The answer is automatic, no. Good practice, yes. I would say, but it depends again on, for example, these issues might be coming before an expert where if liability is still being disputed, maybe there have been no interim payments, maybe the rehabilitation code hasn't been triggered, and so there will have been no funds available to put in place scaffolding around the client such that some of these things can be tested. So sometimes the expert will be coming to these issues blind. Yeah. And I think that's where the expert having a proper discussion with those instructing them about how far they want them to go, thinking as well about the expert's duty to the court in all this as well. You can see that all of a sudden, it potentially becomes quite complicated.
I mean, very interesting that, and there's a supplementary question from an anonymous attendee, which is a bit spooky, but anyway, it says, I don't often see capacity mentioned in instruction letters for C&P reports, condition prognosis reports. What would you routinely expect a solicitor to include in terms of capacity assessment requirements within a letter of instruction? So maybe we'll come to that later, a bit more specifically, but I think these are very relevant questions. I have to say, in my own experience, as you pointed out, I think earlier, the concept of making a capacity assessment is often just tagged on at the end of a letter of instruction, and oftentimes not. And in fact, sometimes whenever I have perhaps ventured to comment, I've been asked not to comment on it, but to wait until I'm asked to comment. So I think this is quite a difficult area for experts.
It is a difficult area, and of course, experts may be instructed by solicitors who, for good reason or otherwise, haven't identified that capacity, may be an issue. I mean, certainly, capacity is something when I see clients that, having done this work for a long time, it's right at the forefront of my mind. It's why I always see clients at home for that additional context, very rarely the office, why I will also speak with other family members, because one of the classic sort of symptoms or deficits presented as a consequence of head injury will be a lack of insight. So you say to that person, do you think you have any problems with managing your money or making decisions? Well, no, I'm absolutely fine. So it is a complex area, and it is becoming increasingly complex. But I think that the key relationship there is between the solicitor, the instructing solicitor, and the expert. And I think, if in doubt, certainly from the expert perspective, if you start to read things in the documentation that you've been sent, but nothing that alert you to the fact that there might be capacity issues, but they're not raised in the letter of instruction, you should perhaps be picking up the phone and saying, I've read this. what's the detail behind it? Has there been any examination of this? But usually, certainly by the time I'm instructing experts, I've got a good idea of where I think capacity sits.
So that's about being an active expert, isn't it, rather than just purely passive and responding to
exactly. And I see that, as completely compatible with the expert's duty to the court.
Yeah. Okay. Well, thank you for that, Hugh, clarifying that.
So next slide, please. And again, just in relation to the internet and social media, the use of spyware, which is something that I see increasingly come up with clients. Most social media platforms are available to those 13 years old and older, although often youngsters will embark upon their journey with social media before that. But the retort which is sometimes thrown at this area is, well, of course, one can look at spyware to monitor the use of social media and perhaps offer some sort of protection against harm. We've already seen, in terms of the principles of the Act, enshrined within that, looking at the least restrictive option, but also spyware, I've got to say, raises all sorts of GDPR and deprivation of liberty and human rights issues, and is something that should not be lightly skirted over. But I think that for the purposes of today, raising the flag is sufficient, but certainly something to be aware of. Next slide, please. And then sexual relations, again, in terms of capacity assessments and what experts may be required to look at, this is extraordinarily complex, and it would be useful, I think, for those that as practitioners have more exposure to this in terms of their day-to-day practice, go away and have a look at read JB and some of the commentary on it. Went all the way to the Supreme Court, and it and the analysis of it since provides quite a lot of background and guidance to how consent to engage or consent to or engage in sexual relations should be considered. Again, coming back to the question that was posed earlier, to what extent should these issues perhaps be ironed out before they come to the expert? This would be exactly one of those topics where I wouldn't be expecting an expert to start from scratch in trying to work out whether a client or a claimant does or does not have capacity to engage or consent to sexual relations at the point of the medico-legal assessment. Next slide, please. So perhaps let's put some of this in context, because I think that does help. So this is the case of Louise, accident in 2012, aged 12, severe traumatic brain injury, then discharged home into the care of the family. The family initially instructed solicitors, signposted to them, but who weren't expert in this area. They did subsequently transfer their matter to us, although for 2 years refused to transfer their file of papers, notwithstanding the usual assurances and undertakings that we gave. Very little progress. There was a deputy, so capacity was assessed early. So this is for a minor, and let's not forget that when looking at capacity in those circumstances, we're looking at whether or not capacity is still likely to be lacking when they reach 18. If that's not thought to be the case, then the courts will prefer to delay that decision until they do reach majority. But with this particular client, pretty clear early on that she was still going to lack capacity to manage financial affairs on reaching 18. By the time the claim came to us 7 years in, there wasn't even an admission of liability that had been obtained, and none of the experts that had already been instructed were we able to retain, just because they just weren't up to the task. Next slide, please. So Louise, as I've called her, she's very much sort of walking wounded. She has some physical deficits that are not immediately obvious to the eye, but they become increasingly so. So you could walk her down any high street in the country, and you wouldn't know. You would start to know perhaps if you started to talk to her, and the more time you spend in her presence, the greater her range of deficits are revealed. She is subject to an EHCP. She does have very significant cognitive, executive, and behavioural issues, very vulnerable, and that certainly manifested itself in her use of social media. And at one stage, it became apparent that she was being groomed by an adult living in the Middle East, but posing as a teenager in this country. Not that much statutory support, safeguarding and deprivation of liberty issues, recent sex abuse by a family member, and lots of capacity issues that we will look at going forward. Initially, the defendants put forward an offer of 1.5 million. That's relatively recently gone up to 10. It's worth significantly in excess of that again. But imagine those circumstances where being under a duty to report offers to your client, and a family member is the litigation friend, to tell them that the defendants value your relative's injury as one warranting an award of £1.5 million. Defendants, that does not help. It just further entrenches the parties, and you can see that 6 months later, an offer of £10 million on the table. Next slide, please. Again, a little bit of history, which I'm not going to go into here, but Footanstey Trust Corporation appointed in place of the existing deputy. And here's the crucial thing: application made on the 11th of March 21 in respect of a broad range of issues that we suspected the client lacked capacity in. Residence, so choosing where she would live, care, support, contact with others, social media, internet, sex, relationships, contraception. Application made to the court. Court came back and said, no, want the local authority to deal with those issues. Next slide, please. And here we are, almost 12 months later, and those capacity assessments are either still outstanding, in part, or were very late in being dealt with. Next slide, please. So the social worker that looked at the matter, accommodation and care had capacity, although they've subsequently changed their mind since. Social media lacks capacity. Unsupervised contact with others lacks capacity. Sexual relations lacks capacity. And where are we at the moment with all that? There are DOLS issues, deprivation of liberty issues being addressed. Lots of dealings with the local authority still. It is, it is extraordinarily complex on a day-to-day basis. Next slide, please. And this is what it does to the costs. In the second year, so this is the the first management year, second management year, this is when these issues were starting to be explored. And those figures that you see on the screen in front of you, £31,000 in 2020, 31 effectively again in 21. Those are costs that have been assessed by the court. So those are not figures that have just been dreamt up. That's following a scrutinization of the costs incurred, with those then being deemed reasonable. And in the current management year, we're only a relatively short way in. These issues are massive day to day, taking up huge resource, and you can see cost to date £6,500 annualized, nearly £70,000 per annum. And going back to historically how perhaps capacity was dealt with by experts, finance and property, maybe testamentary and litigation capacity in the report, and the deputyship expert would often say, well, this is what the costs have been to date, but going forward in year one post-settlement, I think there'll be X amount. They'll be quite high. They always are. Post-settlement, you might be buying a house, investing the money, etc. But that they will then start to settle down. Well, that assumes an awful lot. And actually, I suspect for this particular client, she will have ongoing issues around her capacity on these health and welfare issues, requiring constant management, scaffolding, reassessment, such that the costs going forward will be, very considerable indeed. Next slide. So how should we be looking at the evidence gathering in this sort of case, and what should the experts expect? I've talked there about witness statements. They are so important. I think as solicitors, they are one of the biggest differences that we can make. Also, it does help if these issues then, when identified, are explored in depth, and that we can't expect an expert, I think, to deal with that just in the course of their instruction. And an hour, hour and a half, 2 hours, maybe more sometimes spent with the client. On this particular case, the experts are getting the advantage perhaps of understanding all that has happened to date in terms of the deputyship issues on the matter, and can see what forensic analysis has been undertaken of them. And of course, then can choose, and I'll come back to this in perhaps my penultimate slide, as to what they do with it in their report. Do you defer to what's happened on the ground, or do you perhaps, as an expert, decide you're going to yourself be more forensic, and you might even reach a different outcome? I see frequently defendant care experts saying, well, this is the sort of case where a pendant alarm is the answer, and this particular client doesn't need the care that's being suggested. They need the freedom. They can just have a pendant alarm to use whenever they think they're getting into trouble. It doesn't work. It really doesn't work. Not for these sorts of clients. And sometimes separate statements around discrete issues. So rather than these issues being buried in more broad-ranging witness statements, perhaps to have witness statements that are more defined in terms of certain things. So, for example, on this particular case, where we needed more suitable accommodation, and the family are now in more suitable accommodation, which will accommodate care. Some specific statements around the search that was undertaken for that accommodation. We also have two experts for the deputyship and court protection evidence and costs. One to deal with finance and property costs, and the other to deal with the health and welfare issues, just because traditionally those tend to be kept separate within firms. We have a finance and property team, we have a health and welfare team, and if you're an expert, you tend to come from one of those backgrounds or the other. It's a bit like asking medical experts otherwise to deal with sort of cross-discipline issues, maybe not quite that extreme, but you perhaps take the point. Next slide, please.
Hugh, can I just come in there? Just to let you know, we're at sort of 15 minutes to go approximately.
Yep.
I think there are quite a few interesting points we could discuss once you're wrapped up.
Yeah, which I'll do as quickly as I can. Only a couple of slides to go. So from the experts' perspective, what are you being asked to consider? You might want to clarify your instructions, understand what the legal tests applicable are. We know that different tests applicable to managing finance, to testamentary capacity, to litigation capacity, but what about sex? What about social media? Some of these other health and welfare issues. What's the evidence that sits behind it? What's been happening on the ground? Useful in Louise's case that the experts have the benefit of, albeit over a long period of time, massive in-depth analysis of these particularly health and welfare issues. Where are you going to see the claimant? Dragging them all the way down to Harley Street may not be the best way of extracting the information that will enable you to best assist the court. How much time are you going to need? Will it take more than one visit to the client? What potential criticism are you exposing yourself to if these issues aren't dealt with in the depth that you should be looking at them? And if you're not looking at these issues in depth, what does the court then do with the balance of the opinion in your report? And of course, what does it do to your cost estimate when you're being asked to report? Are there these more complex features that mean that the cost estimate is going to need to be revised upwards? So Ed, some things there to think about, and I'll just skip on then to my last slide. Sometimes, and this will be, I think, useful. I'm giving away a bit of a secret here, perhaps, to defendant solicitors present and also barristers that are instructed by defendants. It's trite, perhaps, to say that capacity needs to be addressed early. But here's one of the bear traps. Once a defendant has served evidence as to a claimant's retained capacity, that has to be put before then the court of protection if an application is then subsequently made to appoint, so a first application to appoint a finance and property deputy. We can't mislead the court of protection. And if there is a contrary view on capacity, they need to have it. And in those circumstances, what the court of protection will usually do is say, we're not going to make a decision. The High Court is going to have to deal with this dispute before we will be content to appoint a deputy. So better, as I say, to deal with these issues early on the litigation side, pass them over to your mental capacity team if you're on the claimant side. If you've already issued proceedings, what could you do? Or you're about to have to issue court proceedings and you want this issue of capacity resolved. If you're issued, maybe to have capacity dealt with as a discrete issue before anything else, obviously if liability is otherwise admitted. If you haven't issued proceedings yet and you don't want to, maybe Part 8 proceedings just to focus on resolving capacity. And another option, sometimes it is very useful for, I find, if case managers have got a concern around capacity and I'm still a way off instructing my experts, so this is quite early on, I might say to the case manager, well, if you've got concerns, you go ahead and commission an assessment of capacity. In those circumstances, probably around finance and property, but could go further. That is my whistle-stop tour. I'm very happy to take questions, open it up to discussion. I hope what I've been able to convey in a relatively short period of time is just how complex this area has now become, and some of the things that as practitioners in this area we should all be thinking about.
Thank you, Hugh. Yes, indeed, you have done that. A very comprehensive overview, which I found informative, as always, with your talks, and helpfully detailed. If I can just make a couple of comments. In fact, we don't have very many questions. The audience seems to be rather shy.
Stunned.
I don't know, stunned by the content, hopefully. But if I can just ask a question of my own, which is, I've got a question and then a point I want to make. The question is about the hierarchy of experts who make capacity assessments, because I often involved in complex brain injury cases, and there will be a neuro rehab expert, that would be me, there'll be a neuropsychiatrist, there'll be a neuropsychologist, and oftentimes everybody's asked to make an assessment of capacity. And then when we get to a conference, there can sometimes be disagreement about that, and it leads to quite a lot of quite tricky debate, actually. It really puts you on your mettle. And so my question to you is, what is that hierarchy? Whose view would you rely on most out of those three, accepting that it isn't always medical doctors who do this or psychologists? I know that social workers do it. I know other people are quite able to do it. But let us take my live example of those three on a really major traumatic brain injury case. How do you resolve that? And whose view would you rely on?
Yeah, it's difficult, and I don't think one can sort of really generalize, because if you looked at neuropsychology, neuropsychiatry, rehabilitation, for example, you could take different experts in each of those disciplines, each of whom will have different experience of dealing with this. So I really do think it varies. Where do I normally start anyway? In terms of the expert sort of reporting, often neuropsychology, just to sort of give me that idea of deficits as they present, subject, of course, to thinking about things like the frontal lobe paradox and the need for ecological validation. Equally, neuro rehab.
Questions are tumbling in now with only a few minutes to go.
Equally, neuro rehab and also neuropsychiatrist. One of those things really where there is no obvious hierarchy.
Okay, so there's a question from an anonymous attendee. I'd like to know who it is, saying, how about neurology versus rehab medicine? Well, there's a very interesting discussion there about the role of neurology and neurological rehabilitation in the approach to expert witness work in brain injury cases, and I'd be very happy, whoever that is, would please email me. I'd love to get into a discussion with you about that. There's from Lisa Connolly, very interesting talk, thank you.
So just picking up on Collins, if he doesn't mind me referring to him by his first name, should it not be the expert who's got the most objective, detailed assessment, who perhaps takes the lead on this, not just a specific hierarchy? Absolutely. That as I say, that there is no right or wrong. And when I'm pulling together, as I know my defendant colleagues will, a number of experts on a particular matter, it will vary. Sometimes it'll be, one, sometimes it'll be, a different discipline. It depends as well on what's been happening on the ground. Is it a case like Louise, where a lot of forensic examination has been undertaken looking at these issues, or is it something that, the experts are looking at afresh? We all need to approach every single case, I think, with a degree of objectivity, and that there is no one size fits all approach. So
if I may just give you a very quick anecdote of my own. I was asked 8 months ago to undertake a life expectancy assessment of a gentleman injured with brain injury and a cord injury. He vacillated about whether he wanted this. About 3 months ago, I was actually told he didn't want that, but he did want, the solicitor wanted a capacity assessment. So I had already asked for the medical records. They hadn't been provided. And so I said, well, really, I don't know anything about this guy. I would really like to see at least his GP records. And eventually these arrived, 2,500 pages of them. And I trolled through them and found a lot of very, very interesting and relevant material. I was then stunned to find that I was being harangued by a firm of solicitors that was not involved in a litigation. This is a settled case, and they had been contacted by this client to hurry the process along. I was then contacted by his social worker in a similar vein. And then the firm of solicitors who were the experts, solicitors in capacity, instructing me, were then contacted by the Office of the Public Guardian, admonishing them for me taking my time reviewing the records. In fact, I'd only taken about a week reviewing all these records because they'd been really delayed. And it was extraordinary. Questions are being asked. Why on earth does this doctor need to have a look at the medical history? It was the most extraordinary case. So eventually I had to withdraw from it because the client was really quite hostile towards my involvement and indeed the firm solicitor's involvement. So what's your take on that, Hugh?
Well, I think one's professional reputation, should and integrity and duty to the court should always trump those issues. Yeah, I think we've probably all, seen or maybe even had direct experience over the years of situations where you just have to say, look, I'm really sorry, but I can't continue.
Exactly, and that's what I did, unfortunately. So just there's a question here that's another anonymous attendee says, to summarize, as experts, can we simply just state in our report that we recommend certain assessments be undertaken due to ... the concerns we have addressed briefly during the assessment? We are not experts in every avenue. So yes, can you suggest further assessments? My own view of that's yes. What about you, Hugh?
Yeah, I'd completely agree. And I think that goes back to the duty that the expert has to the court. And rather than, and I'm perhaps exaggerating for effect, but rather than stick a finger in the wind, actually, if there is significant further work that you as the expert think should be undertaken before a determination can be reached, it's absolutely right to flag that. Okay,
great. So we are now a minute and a bit away from concluding. I think what I'd like to do now is thank you, Hugh, very much for a really energetic and detailed and expert presentation, very fluent and very clear, actually, really, really helpful. And thank our audience for attending. Some very useful, interesting questions there. I would have liked to see a few more, but then again, one is caught trying to answer them all at the end. Perhaps if anybody's attending any future events of ours, which there will be, please chuck your questions in early so that I get a chance to digest them. Just to say, we had at the peak 104 attendees today, which is about 60% of those who said they might be able to, which is an excellent result. There are many people now just messaging in to say thanks and thank you very much and so forth. So Hugh, I think you can regard that as a very, very well spent hour. We're grateful as the audience, and we at NRC Medical Experts are to you. So I think without further ado, we'll wrap up there. Bang on time.
Thank you very much. Thank you all.
Thank you, Hugh. Bye-bye now. Bye, everybody.